Is one man really so powerful that he could destroy the entire country? And is that the way our political system was designed to work? Ciao everyone, this is Nate on the Stone. Welcome back to my channel. Those are some of the questions that we are going to be talking about today. And don't forget that if you like videos about cultural, political, and religious commentary with a different point of view, then subscribe to my channel and ring the bell for notifications. Last week, the Senate Judiciary Committee started hearings on Brett Kavanaugh, the man who President Trump nominated to the Supreme Court in July, and reactions were interesting. Celebrities like Rosie O'Donnell and Cher said that women would literally die if Kavanaugh was confirmed to the Supreme Court. Senator Diane Feinstein said that we would go back to the dark ages where between 200,000 and 1.2 million women died because abortions were illegal. Senator Kamala Harris and her office twisted Kavanaugh's words to make it seem that he was everybody's favorite boogeyman, the religious fanatic. People specifically entered the hearing so that they could disrupt it, and after being arrested, posted their arrest as a mark of bravery and of resistance. There was even a group of women dressed like the characters from The Handmaid's Tale, giving the not-so-subtle implication that if Kavanaugh was put onto the Supreme Court, America would be transformed into a Christian theocracy where women would be third-class citizens at best. Putting aside whether these accusations are actually true or not, what's really telling is that our political system has been allowed to dissolve to the point where one man either has or seems to have so much power to completely destroy what people think the country is. Remember, the American Founding Fathers were very suspicious of power in any one person. Their experiences with England and their own understanding of human nature showed them that nothing good ever came when any one guy started consolidating power. Their answer for the new country was twofold. First, they divided power between the local, state, and federal levels of the government in a system called federalism. And then, at the federal level, they divided power again three ways. The legislative branch, Congress, was given the power to make the laws. The executive branch, the presidency, was given the power to enforce the laws. And the judiciary branch, the Supreme Court and the lower courts, was given the power to judge the laws. And when you get down to the specifics, the really nitty-gritty, power is divided even more within the three branches. The legislative branch, divided between the House of Representatives and the Senate, has 535 legislators in total, 435 in the House, 100 in the Senate. The executive branch has the president, the vice president, and the secretaries of the 15 departments. The judiciary has the 9 justices on the Supreme Court, and then 179 judges of the federal appellate courts, and 680 judges in the federal district courts, giving a grand total of 868 federal judges. So, just to put everything in perspective again, Brett Kavanaugh, whom people are saying if he's put on the Supreme Court will cause women to die and everything like that, he's being asked to fill one seat out of 868 seats in one of the three branches of the federal level of the government. On top of that, the seat that he's being asked to fill is in the weakest of the three branches. James Madison, writing in the Federalist No. 78, says the judiciary has no influence over either the sword or the purse. It may truly be said to have neither force nor will, but merely judgment. What Madison was saying was that since the court couldn't make laws or enforce the laws, all it could do was really give its opinion about the laws, meaning that it was the weakest of the three branches. An example from 1832 bears this out. That year, the Supreme Court decided in Worcester versus Georgia that the Cherokee Nation was a sovereign nation, and so the state of Georgia couldn't enforce its laws within Cherokee territory, and the United States government couldn't enforce U.S. laws in the Cherokee Nation's territory. When President Andrew Jackson heard about the Supreme Court's decision, he famously declared that the Supreme Court had given its opinion and now it could try to enforce it. after which Jackson promptly booted the Cherokee off of their land and sent them packing to Oklahoma on the Trail of Tears. Now, James Madison went on to say in the Federalist that the judiciary branch could never threaten the liberty of the people, provided that it never got mixed up with the legislative branch or the executive branch. And for a while, this is actually what happened. From roughly the founding of the country until the end of the 19th century, the Supreme Court was seen as only having judicial review, meaning that it could declare certain laws null and void, but only if they obviously contradicted the Constitution. It was understood in these cases that the court wasn't enforcing its own will, but just the Constitution. And it could enforce the Constitution because there was a broad consensus about what the Constitution actually meant. It was agreed by everyone that the Constitution had been written with specific goals in mind, and that its meaning could be understood by reading the words and defining those words, and then putting those words in the context of the document itself. And then at the end of the 19th century, this all changed. Darwinian evolutionary theory was tacked onto the Constitution, meaning that it didn't have a solid foundation anymore. It was starting to become what's called today a living document. In 1881, Supreme Court Justice Oliver Wendell Holmes wrote in his book, The Common Law, that constitutions are basically just outlines of general principles that are hazy to apply at best. And so that means judges really have to act as legislators, where they will be able to apply the general principles as best they can, with the modern social problems of the day foremost in their mind. The result was that the Constitution stopped being seen as a document that had intrinsic meaning on its own. Instead, it was dependent on the judges and the judge's interpretation of it in application to whatever was seen as being the modern problem of the day. And this has come to be known as judicial activism. Some people have defended judicial activism. Dr. Susanna Sherry, a constitutional professor at Vanderbilt College, has said that judicial activism, which she defines as the court overturning any piece of legislation, is necessary because it keeps democracy in check. She points out, correctly, that the founders were very suspicious as to democracy, and she argues that judicial activism is necessary to protect people from the changing opinions of a temporary majority. According to Dr. Sherry, it's better for the courts to be activist and strike down too many laws, bad and good, than for the court to be reserved and strike down too few laws, bad and good. Because she argues that it's better for bad laws to be thrown out with some good laws than for bad laws to remain on the books alongside good laws. She reinforces her argument by showing what has happened when the Supreme Court hasn't been activist enough and has allowed horrible laws to stay on the book. One example she gives is the 1927 case Buck v. Bell, in which the court upheld involuntary sterilization. In cases like this, Dr. Sherry argues, it doesn't really matter how the laws are overturned or what reasonings are given for overturning the laws, just so long as they are overturned. Basically, the ends justify the means. I've linked Sherry's article down in the description below. It's a really good read, and she makes some valid points, like when she points out that people on both sides of the political aisle have thrown out accusations of judicial activism just to attack decisions that they don't like. But all in all, her defense of judicial activism falls flat. And the main reason for that is not so much that judicial activism has led to as many bad results as judicial inactivity, but that judicial activism on a deeper and more fundamental level has allowed the court to amass far too much power. Take the example of Roe v. Wade. I spoke about Roe v. Wade way back when in my second video, but it's a point that bears repeating. In his majority opinion, Justice Blackmun argued that the 14th Amendment's concept of personal liberty is broad enough to cover abortion. He also argued that since the right to privacy covers other aspects of family life like marriage, procreation, and contraception, and child rearing, then it covers abortion too. But as one critic, Norman Vieira, said, that argument doesn't follow, because just because the idea of the right to privacy covers some aspects of family life, it doesn't follow that everything that could be covered under family life is equally as protected. But perhaps the most damaging dissection of Roe v. Wade came in 1973 from John Hart Ely, himself a constitutional professor, and a man who admitted that if he was a legislator, would vote for a bill that legalized abortion in as vast a scope as Roe v. Wade had already done. Ely out and out said that the right to an abortion had nothing to do with privacy as it was written in the Bill of Rights. Furthermore, he said it was funny that the right to an abortion was given more stringent protections by the court than the right of free speech, even though free speech was clearly written into the Constitution, but that the right to an abortion could be found nowhere in the Constitution or anywhere in the framers' thinking. Conclusion? The right to an abortion was created out of thin air by the Supreme Court. Take another example, the 1992 case Planned Parenthood versus Casey, in which Supreme Court Justice Anthony Kennedy wrote in his majority opinion that at the heart of liberty lies the right to decide the meaning of one's own existence, the universe, and the mystery of human life. Which basically means that the Supreme Court gave everyone the power to become their own demigods. In a sense, it's no wonder that people have become panicked over the possibility of a Justice Kavanaugh. When the judiciary branch, particularly the Supreme Court, can make up rights out of thin air, when it can tell people that they are basically demigods who can decide for themselves the meaning of the universe and human life, never mind what biology, history, philosophy, psychology, or religion says, then there really is no limit of its power. And justices morph from judges to beings of godlike power, basically gods on earth. And this is dangerous for everyone who is concerned with liberty, regardless of whether you identify with the right or the left end of the political spectrum, regardless of whether you vote Republican or Democrat or Libertarian or Green at election time, and regardless of whether you consider yourself conservative or progressive or libertarian. And the reason for that is because nothing is built on solid ground anymore. Practically speaking, we no longer have rights because they're recognized as being inalienable because they come from human nature or a creator. We have rights because the judiciary branch says that we have rights. Dr. Sherry and others may argue that judicial activism is necessary to protect people from the whims of a majority. But who is going to protect us from a judiciary branch that has the sole authority to interpret the supreme law of the land into basically whatever it wants at any given moment? Packing the courts isn't the answer. The only way that we can fix this is by realizing again that the Constitution is not dependent upon a judge's interpretation of it, but that it has intrinsic meaning on its own. Because only when the Constitution again becomes an objective standard will the rights of everyone, the legitimate rights of everyone, be protected. But what say you? Has judicial activism transformed the court into a god on earth with potentially limitless power? Or is it a necessary tool to protect people from the tyranny of a majority? And all we really need to be worried about is putting the right people on the benches. As always, let me know what you all think down in the comments below. Well, that's all for right now, gang. If you liked this video, whether you agree with me or not, don't forget to subscribe to my channel and play the Hunchback of Notre Dame and ring that bell for notifications. I post new videos like this every Tuesday. As always, thanks for watching, and I will see you all again here next week on Top of the Stone. Ciao.